Could the Ripple case change the rules for crypto forever? Cardano's Charles Hoskinson humorously suggests a Ripple test might replace the long-standing Howey test if Ripple wins the appeal. The U.S. Securities and Exchange Commission's (SEC) decision to appeal the recent ruling in its case against Ripple continues to stir debate across the cryptocurrency community. On October 2nd, the SEC filed an official notice of appeal, signaling its intent to challenge Judge Analisa Torres' ruling in favor of Ripple regarding the sale of XRP. One of the most notable reactions came from Charles Hoskinson, the founder of Cardano, who added a humorous twist to the legal drama. Responding to Ripple's chief legal officer, CLO, Stuart Alderoty's comments about the SEC appeal, Hoskinson jokingly proposed that if Ripple wins, the Ripple test might replace the Howey test as the new standard for determining whether assets like XRP should be classified as securities. Ripple's CLO, Stuart Alderoty, expressed disappointment over the SEC's decision to appeal, but made it clear that Ripple is more than ready to fight back in the U.S. Court of Appeals for the Second Circuit. Alderoty emphasized that the case against Ripple is fundamentally flawed, and the company remains confident in proving that the SEC's arguments are misguided. In a potential twist, Alderoty hinted that Ripple might file a cross-appeal, which could allow the company to challenge any parts of Judge Torres' ruling that didn't go in its favor. This opens the door for Ripple to pursue even broader legal victories as the case moves forward. For decades, the Howey test has been the legal benchmark for determining whether a transaction qualifies as an investment contract and therefore a security. The test, derived from a 1946 Supreme Court case between the SEC and W.J. Howey Company, requires that a transaction meets 4 criteria. It must involve 1. An investment of money, 2. In a common enterprise, 3. With the expectation of profit, 4. Derived from the efforts of others. The SEC has long used this framework to argue that cryptocurrencies like XRP should be classified as securities. In Ripple's case, the SEC claimed that XRP was sold to investors as an investment contract, violating federal securities laws. However, Judge Torres ruled that Ripple's programmatic sales of XRP and its other distributions did not meet the 3rd and 4th criteria of the Howey test. Specifically, she found that retail investors buying XRP did not expect to make profits based on Ripple's efforts, which led her to conclude that these transactions did not constitute securities. While Ripple's victory in these key aspects of the case was a significant win, the ruling doesn't yet hold the weight of a legal precedent. Some courts, such as in the ongoing SEC lawsuit against Terraform Labs, have already rejected the logic applied in Ripple's case. However, if the Second Circuit Court of Appeals affirms Judge Torres' ruling, the decision could set a legal precedent and possibly establish a new framework for determining the status of crypto assets, a development humorously dubbed by Hoskinson as the Ripple test. This hypothetical Ripple test would mark a significant shift in how U.S. courts classify cryptocurrencies, potentially moving away from the outdated Howey test to something more relevant for digital assets. While the SEC's appeal moves forward, legal experts speculate that the case could drag on until early 2026, depending on how quickly the Second Circuit delivers its verdict. In the meantime, the possibility of a cross-appeal from Ripple and growing speculation about the case's implications keep the crypto community on edge. The potential for a new legal framework to emerge has fueled speculation that this case could fundamentally reshape the regulatory landscape for crypto in the U.S., with Hoskinson's joke about a Ripple test underscoring just how big the stakes really are. So, that's the update for now. Thank you for watching, and see you in the next video.